My name is Mark O'Brien. I'm an attorney here in the estate administration department. Estate administration is really just a general overview of the department. What estate administration truly means is probate administrations, trust administrations, conservatorship administrations, guardianship administrations, fiduciary accountings, contested matters, some probate and trust litigation, as well as some tax administration and tax disputes. So kind of estate administration encompasses all of those aspects. At prior firms, I also did a lot of the same practice that I'm doing here at Copenbarger, but I also did some estate planning, some business and succession planning, as well as tax planning. So really all under the gambit of what this firm encapsulates. This is just a disclaimer provision, right? I'm sure all of you are familiar with these. The information is provided for educational purposes only. It should not be considered legal, accounting, or tax advice. Like I said, every matter is unique, and I'll kind of iterate that as we kind of move forward through the webinar. We strongly encourage you to discuss these with your attorney, your accountant, or tax professional. And although I do work potentially at a firm that you do have your attorneys at, as this is not an attorney-client relationship, really just an informative, hey, these are things to be aware of. Everyone's case is different. Make an appointment, give us a call, and we'll walk you through your particular aspect and give you tailored advice that will help you move your matter and your family forward, okay? Some attorneys at our office, you can see, some you may be familiar with, some you may not be, but we have quite a few different attorneys. As you can see, we have quite a few estate planning attorneys. I'm sure most of you are familiar with Lloyd and Larry, potentially Victoria as well. Mark has been a new hire estate planning attorney. He's been practicing for years. He's helping out the estate planning department, and a lot of people have been meeting with him lately. We also have business and tax with Sonny and Catherine. And then, as you'll see, the estate administration department is James, who a lot of you may be familiar with, myself as well. And then Megan, who's another associate attorney in our department. We also have Elaine Alston, who handles our estate litigation. Chris is our CEO, and Stan is now retired, happily retired, and he comes by every once in a while. Just a picture of our kind of our main general staff. So paralegals, legal assistants, support staff, marketing, accounting, you name it. As you can see, kind of there in the front row, bottom right, I did not get the memo that it was going to be a dark suit day. I wish they would have told me that, and I would not have stand out so much. Some locations, I'm here in our South Coast Metro. That's here kind of where like Irvine, Santa Ana, Costa Mesa all kind of meet. We also have San Jose, Temecula, Santa Cruz, Pasadena, San Diego, Sacramento, Laguna Hills. Today's agenda. Okay, so now we're going to kind of dive right into really the purpose of the webinar and why all of you are here today. I do see some stuff in the chat. Just realize for any questions, I probably will not answer them as we go through. I will try to save them for the end. If there's any questions that will generally help most of the attendees here, I'll try to answer those to the best of my ability. If it's too specific, again, shoot us a message. You can also send my marketing team an email afterwards with a question, and they will forward those to me. And if I'm able to answer those, I can even answer them afterwards, okay? So let's dive right in. Today's agenda, these are a couple of the main overarching topics that I'll be discussing. Role and importance. So what is the role of a trustee? What is a trustee? What is the role of a trustee? And some things to be aware of in that regard, right? Along with that, what happens first? So this is really focusing on, okay, your loved one has passed away either recently or you have, maybe not as recent, maybe it was a little while ago, but you have now had the time to grieve and you're able to effectively and responsibly move forward with your role as the named trustee. What has to happen first? Who's responsible? What does that look like? And obviously some things to be aware of as you're navigating that process. And some things that you can be aware of, and also things to make it easier for yourself and for the professionals that you're working with. Next, common mistakes, right? Some pitfalls and common mistakes that we commonly see. Some of them that I discuss are avoidable. Some of them that I'm going to raise are not avoidable. So as a part of this, you'll see I'm going to mention some things where it's like, okay, even though we know this is not avoidable, be aware for it, potentially brace yourself for it. The more prepared you are, the easier the process is, even if it's out of your control, right? And I'll try to highlight what's in your control and what's not. And protecting yourself, that kind of goes hand in hand with preparation, right? If you prepare appropriately, you're most likely going to be protecting yourself most of the time. And then for the other areas where you're not able to, that's where the advisors come in. That's where your attorney comes in. That's where the financial advisor comes in, CPA, whoever else. Okay. And then some key takeaways. I'll kind of summarize and highlight some of the real key aspects that I want you to walk away with as a part of this. I did talk with my marketing team. We're going to be trying to come out with more of a series of this. We had so many signups for this and some of my other webinars that we're going to try to give even more information to our clients, to their family, to the public. Hey, this is kind of like I said, the focus of this one is the first 30, 60, 90 days. Maybe the next couple of series, we're going to focus on the meat and potatoes, right? The middle of the administration. We can focus on just the tax portion. We can focus on what final distributions look like. We're going to try to break it down in a series so it's really digestible and so that all of you really truly understand at a granular level what it means to administer a trust, okay? Moving along, role importance, right? Understanding the why. Okay, so you can see from the bullet points here, and again, this is role importance as it pertains to you are named as the successor trustee of your family or friends or loved ones trust. Okay, and they have passed away. You are named as trustee. What does that mean? What is the role of the trustee? What are the duties? What are the liabilities? What are the responsibilities? Okay, so you'll see here legal responsibility to manage trust according to the law and trust terms, right? Your duty as a trust is to follow that document, right? It is an instruction manual, it is a playbook, and your duty is to follow that. Sometimes, and again, a lot of that is done to protect yourself, to honor the wishes of that loved one, and to protect the beneficiaries and distribute and handle the assets based on the loved one's wishes and desires. Sometimes the beneficiaries don't like that, right? Sometimes they don't like what's in that document, but your job as trustee is to follow that. And again, we would help guide you through what that means, what that looks like, okay? Next, we have fiduciary duty to act in the best interest of the beneficiaries. So as a trustee is a fiduciary, and a fiduciary just means you're kind of acting on the behalf of someone else. It means your duty is to that entity or person, right? In this case, your duty is to the trust, which is its own entity, but also to the underlying beneficiaries. So you have numerous fiduciary statutory duties to the trust and its beneficiaries. So your decisions, even though you're following the trust terms, right? You're following the instructions and you're moving along in the process appropriately. You have a duty to those beneficiaries. Okay, so you can't take actions that are going to injure or harm those beneficiaries. Okay, and we would walk you through that. So if there was an action that you were wanting to take that you were questionable or that the beneficiaries were challenging, we would advise you and guide you on how to navigate that potentially complex scenario. Okay. And then the importance of acting promptly and correctly. Again, this will vary person to person. Sometimes I have family members and loved ones who are named as a successor trustee. And the person has passed away on August 21st, and they are calling our office on August 22nd to make an appointment within the next 2 to 3 weeks. Okay, some people, that's just based on everyone's different grieving process. Some people want to be staying busy, right? Because it kind of keeps them moving forward. Some people want to not have to deal with any of that and push it off to the side. Again, everyone grieves differently. I think a lot of issues that come up is not conveying that grief to the family or the beneficiaries. Sometimes we have a person who is really having a difficult time handling the loss of their loved one, and they know of the trust and they know that they're named the successor trustee, but they take a very long time to grieve, and they really don't start diving into the documents and the assets and the paperwork and the trust and reaching out to the appropriate advisor until 6, 7, 8, 9 months, maybe even a year later. Okay. And not necessarily that, there are some timelines that you want to be aware of and some legal deadlines, but that is still okay. But the main main takeaway I want you to receive is that you need to at least try to communicate that to the other family members. If you do not communicate, that is where the tensions start to rise. That's where the family constraints and the relationship um, starts to weather, because of the fact that you're not communicating that, hey, I am not okay at this time. I am emotionally grieving, and by the way, that's absolutely acceptable, right? Grieving someone's loss is incredibly hard. But at least expressing that to the others and telling them, hey, I'm going to get this, but I need some time. Or conversely, telling them that you are not able to, right? No one can force a trusteeship on you. So even if your name is put in a loved one's document as a trustee, you do not have to accept. So it's a hard conversation that you have to have with yourself and with your loved ones, and talking to those that you trust, to say, hey, maybe I'm not capable of doing this. And that's perfectly fine. And in that case, you would want to reach out to the family and reach out to the attorney and say, hey, I'm not able. I'm not able to do this. I want the next named successor to be the one that handles this. They are a much better suited person based on the current circumstances. And we can guide you through that process. But at least, no matter what, you are still acting promptly and correctly, right? You're still communicating, you're still doing something. Even though you may not accept the role, you're still moving the process along. Okay. What happens first? So I apologize. I don't know if any of you have attended any of my prior webinars. Usually they're very linear and it's more of a process based, for like a conservatorship process. Here's how you file the conservatorship. Here's what it is. Here's why. Here's the next steps. Here's what you have to do. It's kind of more of a chronological. This I may jump around a little bit as things kind of certain scenarios pop into my head, or something that I've recently dealt with. This is really going to be kind of hey, some general things to be aware of, and then here are some um, personal experiences that I've come across, or clients that have come across, that I can convey to you to kind of give you more of an awareness and kind of some strategies for how you move forward, what to be aware of, how to plan, what you are in control of again, and what you are not in control of. Okay. So these are the immediate steps, right? We're talking almost pretty much immediately when someone passes away, shortly thereafter. So I think a really good time frame on the last slide, 30 to 90 days, is a good estimate of what I mean when I'm saying immediate. So locate the trust and estate planning documents. And this will be quite ranging of an experience. Some parents or family members or loved ones share with the successor trustee, hey, here's a copy of my document. It's not required, but some of them are wanting to give that away. Some of them say, okay, I don't want you to have a copy of it, but here's where it's located, right? I want you to know where it's located. Or here's the attorney's business card. So and the attorneys, usually, like our office, we keep scanned copies of all the signed documents. Here's who you can call to get a copy of that, right? And depending on your circumstance, it'll be a different answer to one of those questions, right? Depending on the family relationships, depending on the assets, depending on the complexity, depending on the control of the person whose estate plan it is, right? As some of you know, as we get older, we tend to want to control, and it's very hard for us to give that up. So it really just depends on the person's personality. Some of us, I have clients who share everything with their next in line, really at a very granular level. Some of them don't want to share anything, right? And that's perfectly okay. All of this is okay, but you have to at least give them some type of indication of, here's who you can contact to find the information and documents that you need, right? And that kind of sets up your successor trustee, right? The family member that you've named and trusted to administer your trust estate. Hey, here's where everything is, or here's a person that can show you or give you the information you need to go find those documents. So really, a lot can't be done until you have those documents, because you're not going to know what details are in there, what instructions are in there, and so on. Next, arranging the disposition of remains. So this is a very important aspect. If any of you have done your estate planning here, or otherwise, this is a really good nugget of information that's a little bit different. So the trust, our trust, and most trusts, I won't say all, but most, allow the trustee, the successor trustee, right? You're administering someone's trust, to pay for final expenses, funeral, burial costs, um, and things of that nature, as well as the administration expenses and taxes and so on. so that the trustee has the authority to pay for them, but who has the authority to actually direct, to coordinate and select and make decision for burial and cremation? And that most of the time is the agent in your advanced healthcare directive. Okay. If you have a complete and thorough advanced healthcare directive, that document will say one thing. The primary function of that healthcare directive is giving that person your medical power of attorney, right? The ability to make healthcare decisions during your lifetime if you're unable to, or if you're unable to give informed consent. But concurrently, it also gives that person the ability to make post-death decisions regarding autopsy, regarding burial, whether it's cremation, whether it's some type of, if you're doing a standard, funeral, whether you're going to have a formal funeral and a reception, where you're going to, if you have cremation, where you're burying your ashes, so on and so forth, right? It has all those instructions, and it potentially, and then it also gives that individual the right to do that. Okay. So a lot of times you'll see the agent under the advanced healthcare directive is the one signing the death certificate, is the one authorizing that, it's the one they're releasing that information to. And sometimes in certain situations, the person who's named trustee of your loved one's trust is also named as the advanced healthcare directive agent. And in that case, a lot of synergy, right? Because we're going to have the same person handling all of those. If they are different people, then you should be coordinating with that person in those regards. Okay. So that's something just to be aware of, that those people can be different people. For example, I'll use myself. My younger brother, although I'm located in California and my parents are located in California, but my younger brother is located in Oklahoma. He is named, if something happens to, one of my parents, my brother is named as the successor healthcare agent. He is a travel nurse and has been doing nursing for a decade and a half. He has a lot of experience and education in that realm, and my parents have chosen him to be the backup to each other. Whereas I am named as the successor trustee in their trust and as their backup power of attorney for finances. So that's a perfect example of what I just said, right? I will have to coordinate with him, even though I'm the successor trustee. He is named as the healthcare directive agent. He's the one who is allowed to make medical decisions as well as arrange post-death disposition of remains. So I will have to work with him on dealing with that, right? And if he comes out of pocket and pays for those expenses, he can submit those to me and I can provide cost reimbursement. Okay. Or if I'm the agent for healthcare and I'm the agent and I'm the trustee of the trust and I come out of pocket for expenses, right? Once I gain control of the trust, can reimburse myself. And that kind of just triggered something that kind of goes along with this. A lot of times within the 30, 60, 90 days, the successor trustee does not have access immediately to trust assets. So there are a plethora of instances when that successor trustee has to come out of pocket to pay for initial expenses, to maybe pay for the retainer for a trust administration attorney, maybe comes out of pocket for funeral expenses, right? So you need, very advisable, keep an Excel spreadsheet, or if you're not familiar with Excel or any type of tracking that way, a handwritten a list of notations of, okay, I paid for funeral on this date. It went to this was the payee, this was the funeral home, it was this amount, and then keep a copy of that receipt behind it. And you're going to want to be itemizing that, because once you do become trustee, you are named as trustee, but once you accept your role, you meet with the attorney, you start gaining access to all the assets, you're going to want to reimburse yourself or reimburse other family members who have been making payments on behalf of the estate. Okay. And a lot of times, not all of us have millions of dollars to be able to make these expenses. Some of us are using credit cards to front the cost of this until we have access. So you're going to want to keep detailed, accurate records from the get-go, because that just allows you to make quicker cost reimbursements. It allows you to reimburse yourself or other family members much more expeditiously, which again will just help anyone with their own personal finances, while also, that person has done a huge benefit to the estate by providing that. Okay. So just overarching theme of that, keep track of any expenses. Part one, part two, work with the named agent regarding the disposition and the payment of those expenses. Okay. Moving on to the next part, secure property and assets. As a trustee, one of your main fiduciary duties is to secure and protect trust assets. Okay, so for a home, for instance, right? Let's use that because that's a pretty good example. You're going to want to secure it, protect it, right? And now that may mean a multitude of different things. If you're the sole beneficiary, you're sole child of your parents' estate plan, you're the sole beneficiary. We want to say, well, Mark, why do I have to secure and protect the property? Okay, but you need to secure and protect it for yourself, right? If it's now sitting vacant, you want to secure. You want to maybe potentially change the locks. You want to make sure that there's a security system in place, alarms in place. If you a door or ring, some type of camera surveying the property, right? Making sure that you contact neighbors or friends to, if you're, what if you're out of state? What if your parents or loved one own California in Orange County, but you, the successor trustee, live in Oregon, right? You need to be contacting the appropriate people or the appropriate family members or friends to coordinate to say, hey, I may need some assistance with just watching the property, checking mail, make sure there's we don't not dealing with squatters or vagrants or homeless, whatever the case may be. So you can see that there's multiple different things. Also, securing property means if there are tenants, right? If it was your loved one's investment property, you have to secure the property, maintain that tenant landlord relationship. But what if they're not paying? Right? What if they stop paying? And you, as trustee, and there's multiple beneficiaries, it's your job to make sure that they continue to pay. It's your job to make sure you're reaching out to property management companies, discussing with the attorney, and potentially moving forward with, if necessary, an eviction, right? Evicting unlawful tenants is a part of securing the house or the investment property or whatever property it is. Okay. For other assets, for non-real property assets, securing them means contacting the institutions, advising them that someone has passed away, making sure that other family members aren't trying to access, right? Making sure you're doing the things to protect those assets in the interim while you are trying to compile all of the information, compile your affairs, the person's affairs, and getting ready to meet with your attorney, getting ready to meet with the financial advisor, the CPA, and so on. Okay. And again, these are just things to be aware of. Some of these things you can start to do now, and some of these things really you can't do until the time comes, right? If you're, a young 30-year-old, 40-year-old couple has just created an estate plan and they've named a trustee, they can again kind of give some information to that trustee. But until both of those individuals pass away, the trustee really won't know what assets there are until that time of death. Okay, so there's some things you can be aware of and plan for and kind of update as you go along, but there's some things that are just going to have to wait until the actual loved one or family member, friend has actually passed away. Essential documents. So this still goes hand in hand of things you can start to compile, be aware of once your loved one has passed away and you are named as trustee. Okay, obtaining multiple certified copies of the death certificate. You really, as a successor trustee, can't do anything as far as starting to updating title, marshaling assets, making decisions, doing the things you need to do without the death certificate. So a lot of times, people will make an appointment right away, and they don't have a copy of the death certificate. And I say, okay, well, we can kind of walk through the entire administration process and what you'll need, but we can't really do anything until we have those certified copies of the death certificate. I would say on average, and this is very on average, I would order between 5 and 10 certified copies of the death certificate. Okay. Now, will you need 5 to 10? In most cases, probably not. I would say in most cases, 2 to 3 is probably what will actually be utilized. But I would say at a minimum, get 5. A lot of times people will get 2, 3, 4, and I say, hey, in your case, we need 6 or 7, and they have to go back to the county recorder, back to the county clerk's office, and try to order more certificates. Again, it's not necessarily a hard process, but it's easier to get it all done in one fell swoop. You're going to be grieving, you're going to be under stress, family members going to be contacting you, anything that you can do to make your life easier, let's do it, right? Okay, kind of moving on here. Locate the trust, will, property deeds, bank account details, insurance policies, investment records. This is a non-inclusive list, Okay, there's all types of other information that we would want you to compile. What if the loved one had a business, right? We want some business records. If it was their business was in an entity, an LLC or a corporation or was a partnership, we'd want to see those things. This is, if you meet with myself or another administration attorney in our office, we like to send out a list. I send out a list before our scheduled meeting, and it says, bring all of these pieces of information to the meeting. Why? It makes the process move forward more efficiently. If you bring that information, if you have access to it, great, fantastic. It makes the meeting go a little bit easier. It makes my job easier as administration attorney. And if my job is easier, it means your job is easier as a trustee. And ultimately, what that means is a more efficient, a more thorough, and a more cost-effective administration. So that's kind of what I like to a lot of times speak with clients, say, hey, try to bring that. Now, again, if you don't have that information immediately, that's okay, right? Your job is to find that information. And sometimes I have meetings with people and they don't have access to any of their loved ones' information. They're like, I have no idea what assets they had. They didn't share anything with me. I only was notified that I was a trustee because some insert blank entity or institution or financial company contacted me. And then I contacted your office and you confirmed that I am the trustee. And that's okay. We will walk you through how to find these assets, where to locate them, who to contact. And again, we'll kind of guide you through that process. But with, the lack of transparency from the loved one to their successor trustee, that just creates a little bit more work on your end, a little bit more work on our end. That doesn't mean it's a bad thing. It just means a little bit more effort has to go into locating all this information, because without it, we're not going to be able to move the administration onward. So yeah, if you have, if it was our trust, presumably we'd have a copy of it, but we'd like you to bring in anything that you have as well. It's not, as you and I both know, technology is technology, right? It's not perfect. It could be that we scanned a future amendment in, and somehow it's not in our records, but you have a physical copy of that amendment, right? And I may be meeting with you. I have reviewed the trust and I'm ready to give you advice based on that prior trust, but then you have this new document and you come in and say, hey, whoa, Mark, you're talking about the 1995 document. There's a 2015 document that made a lot of changes. And I will say, great, thank you so much for bringing that in. And I will be able to give you the appropriate advice. So that's something to be aware of. Sometimes clients get a little upset because they're like, well, don't you have this or don't you have that? And we say yes, but we only have what the clients gave us when they created this. And it could be that we have not met with them for years, or that circumstances have changed, or assets have changed, or their life has changed, and things have been updated, or there's been issues, right? So we want you to bring all this in so that we can make sure that we're giving you full, complete, and accurate advice from the get-go. Okay. So just be aware those are some of, like, again, non-exhaustive list. Anything else that you have, if it's mineral rights or oil rights or cryptocurrency or retirement accounts, or annuities or, CDs or bonds, or government treasuries. I mean, whatever the case is, whatever assets they have, pensions and so on, we'll want all of that. And we try to list that out on that letter that I send out before you meet with an estate administration attorney. Most of the time, the client is like, whoa, this is overwhelming. I don't have this information. It's not meant to be overwhelming. I always apologize and I'm like, I'm sorry for overwhelming you. It's just A to Z of, here's a long list of asset types. Your loved one may only have a couple of these, and that's what we'll only focus on. Okay. If you have any prior tax returns, that is fantastic. If you have, a tax return from the year prior or 2 or 3 years prior, those are very helpful, because if someone doesn't know where the assets are, it's like, okay, we can at least look at this tax return and know where income is being generated. And that's a good place to start. Or the tax return may say, hey, here's the CPA that prepared it, and you, or as the trustee, or or both of us are contacting the CPA to say, hey, we're trying to find and marshal the assets. We need some clues here. We have a trust from 1980 that lists assets. We know that none of these assets exist anymore, so we need more current asset information. Financial statements are fantastic. You as trustee are going to have to get date of death statements for all assets. So if your loved one passed away, August 21st, 2025, and they had a checking and savings account, you're going to need the checking and savings account statements that covered that time frame. Okay, so most likely the August 2025 statement. And you'll need that for multiple reasons, but regardless, you're going to need that. And you may not be able to get that right away. That's perfectly fine. If you're able to come to that meeting with a July statement based on that example, that's great. Or even a June, or if it's like an investment account and they only issue quarterly or annual statements, and you only have the 2024 statement, that's fine. That's still perfectly that helps out our office extremely, and it also allows you to kind of already start itemizing and listing what assets exist and don't exist at the time of death. And again, I'm gonna take a little bit step back here. This is trust and non-trust assets. I meet with clients, and as I go through the process of the administration, they get a little confused because they say, well, Mark, my loved one created a trust. Aren't all their assets in the trust? And the answer to that is no. There are assets that cannot be titled in the name of the trust by law. And just because you create a trust doesn't mean you funded it, right? If I meet with an estate planning attorney at Copenbarger, I create the trust, and then I don't do anything afterward, right? I just created it. I never funded it. So even though I listed a bunch of assets on an asset schedule at the end of my trust, I didn't go to the banks, change title. I didn't deed my house or other real estate from me to my trust, right? I didn't fund it. So we are asking for information for all assets, regardless of whether it's in the trust or whether it's not in the trust. A great example is I have a life insurance policy on myself. It names my spouse as the beneficiary. Okay, so title is in my name as an individual, not in the trust, and it names my spouse, right? She's not a trust, right? So if I pass away, it goes to her. So we still want that information. And again, if you don't have it, that's okay. Even if you come with a spreadsheet or a handwritten list that says what assets there are, you may not know account numbers, you may not know asset values, you may not know how title is held, you may not know beneficiaries. Any information is really helpful for both yourself and us, as well as the financial advisors and CPAs moving forward. The more information you have, the easier the process will be, the quicker it is, and the less expensive it will be. Again, once you become trustee, if you do not have any of this information, you will have the authority to start contacting all of the financial institutions and the real estate companies and the mortgage lenders and the whole gambit, the retirement company, whoever's holding the pension, life insurance companies, you name it. You'll have the authority to contact them. We'll give you the documents you need to provide them to show that you have the authority, as well as certified copies of the death certificate or copies of the death certificate. Okay, so these are just things to be aware of. This is a good time to have a conversation with, maybe you have your own trust, right? And maybe you've named a family member or a loved one or even a professional as your successor trustee. Maybe this is a good time to sit down with them and say, hey, I know I don't feel comfortable giving you all of my asset information, but I want to at least tell you where my documents are located. I want to at least tell you who my financial advisor is. I have consolidated all of my investments into one portfolio at Merrill Lynch. I do not want to give you the information on that, but here's my investment advisor. I've already told my investment advisor, I've given them your information. I have not authorized you to get any information, but I've told you that should something happen to me, I'm making the connection, right? Giving the information at least so they know where to go, who to go. Okay. And now I'm telling you when to go. Continuing immediate notifications, reach out to professionals. So I've kind of, I've reiterated that probably a dozen times already, so I won't touch on that, but reach out to professionals. Again, everyone does this at different times. Some people do it the next day after their loved one has passed away. That is not necessary. I would say really, the perfect time to reach out is probably within 30 to 90 days, right? 30 to 60 is preferred. 30 being best, 60 being preferred, 90 being okay. After that, as you start to go too long, again, we'll work through it. We'll walk you through it. We'll get through it. It doesn't mean you're necessarily in trouble or anything bad is going on. But, like I said, you want to act timely and prudently, even if that means declining to serve as trustee. Okay. Notifying beneficiaries, notifying heirs, and notifying any co-trustees. And made sure to put this with, and I should have bolded, underlined, capital letters, exclamation mark, with attorney guidance. Okay. Under California, when a person has a trust, and they pass away, during their lifetime, it was revocable and amendable. So they could revoke it, amend it in most cases. Again, generally speaking, there are other scenarios where that's not the case. But when they pass away, it becomes irrevocable. And under California law, you have to give statutory notice to the named beneficiary, to the heirs at law, potentially co-trustees, and potentially others of the administration, the trust, and its irrevocability. I highly advise that you do not provide this notice on your own. This should be a notice that is either drafted by the attorney or comes from the attorney's office, and they can walk you through that. Okay. However, some people will reach out to the family, depending on the family situation. You know, I may reach out to my brother and say, hey, mom and dad have passed away. I'm going to be meeting with an attorney. Just wanted to give you a heads up. There's a trust. I'm named as trustee. I can't really give you much information because I don't really know much information at this time. I'm going to meet with the attorney. I'm going to retain an attorney, and they're going to be guiding me through this process. Okay. Now that is perfectly acceptable because you're being very vague, but while being very vague, you are communicating effectively, giving them a heads up, and kind of them saying, this is the early process. It's going to take some time. Always set the boundaries. This takes time, especially if people are not cooperating or not communicating. It could take even longer. A lot of times people don't understand that it's not the trustee or the attorney who's delaying. It could be a bank. It could be that the mortuary or funeral home is not releasing the death certificate and it's been months and you're still dealing with that, which stalls everything else. It could be that you have tenants that you're trying to evict from property. It could be that the bank is not working with you. The bank won't open up the new trust account for you. The financial institution's having issues. It could be that your loved ones didn't name beneficiaries on assets and you're having to deal with maybe a probate that's delaying things, right? So there's a lot of different variables that are not necessarily your fault or the attorney's fault or anyone's fault, really, but that we are having to deal with that. And if you are effectively communicating with the beneficiaries and timely communicating, giving them a heads up, one, you're satisfying your fiduciary duties to keep them informed, but two, you are creating some cushion for yourself. Okay. And you're setting expectations. Here's part, when I first spoke early on, I said that there are things that are out of our control. Sometimes you provide the transparency and you say, hey, this is what's going on. And sometimes they don't care. Sometimes you're going to get pushback. Sometimes you're going to have contentious family members. Sometimes you're going to have those that don't want to listen to you no matter what you're saying or no matter who that communication is coming from. Even if it's from the attorney's office or the CPA, the financial advisor, it's not going to appease them. So you also want to kind of brace yourself for those individuals. And if you know that there are beneficiaries or individuals that are going to be contentious or where the relationship is strained even during your loved one's lifetime, preparing yourself appropriately will help defend against those individuals, help with the transparency, and potentially help kind of calm their concerns and anxiety over you serving. I'll kind of touch on that, again with the whole declination. If you have contentious relationships or issues with family members and you know that there's no way to resolve it, and your response to that is to not communicate with them, my strong advice would be to, okay, meet with the attorney, tell the attorney that, and work out a scenario where, okay, you're having the attorney handle the communication, but regardless, someone is communicating. If the attorney is not willing to and you're not willing to, then you have to have the conversation of, okay, am I the right person to act as trustee? Or should I decline in favor of someone else that may be able to approach this individual or individuals differently? Or maybe that these individuals potentially trust more, right? And we're having those discussions with you as a part of the initial phase, as part of the initial process. I have numerous times where clients say, I don't want to serve, or there are co-trustees and one says, I'm going to step down. Or there's 5 trustees that are named as co-trustees, and I say, really, only one of you should be acting, and for numerous reasons. And 4 of them step down. One person says, hey, I know that my this loved one named me and I want to honor their wishes, but I'm not at a place in my life where I can do this. I have other issues that are taking up or enveloping all of my free time, all of my focus and effort. I am currently going through a heated and contested divorce, and there is no way I'm going to be able to focus on this while I also have minor children and work issues and parent aging issues, or whatever life throws at you. You may not be able to, and it's appropriate to have that discussion. There's nothing against having that discussion, and it's a very useful discussion to have. Okay, so these are things to be kind of aware of, some things to be keeping in mind, not necessarily discussing at this moment, but keeping in mind as you move forward throughout life and throughout administration, and even through your own estate plan. Okay. Inform key service providers to protect and maintain property and assets. I somewhat referenced this with my real property example, right? Securing the home, making sure locks are changed, making sure tenants are dealt with or evicted if they're not, adequately providing, dealing with, here's a great example, excuse me. Sometimes, parents or loved ones have 4 or 5 children, and one child has moved into the home with the surviving parent, for the purpose of taking care of that parent, right? And that parent has created a situation where, hey, child one, you may move in here and live rent free with me, provided that you take care of me in lieu of me hiring 24-hour assistants, or in lieu of me going into assisted living, or a memory care facility, wherever, or whatever the hospice, whatever the case may be, that person's in there. That can create, even though that may have been from a good place, from a beneficial place from both the child and the parent, the other children and siblings may not see it that way. There may be contention and issue when that parent passes away about that child staying there. Is that child that's staying there the trustee? Are they not the trustee? Are they a beneficiary? Did mom's trust specifically say, I want to give a specific gift to that property to that child, right? You're going to be wanting to be advised and aware of all those particulars. And again, if you're the trustee, that's going to all be set forth in the trust itself. And if for some reason it's not, the attorney is going to walk you through pros and cons. What are your options? How involved do we want to get the other individuals? What kind of communication do we want? Do we want it coming from the trustee, from the attorney, from somebody else? That's a really good conversation to be having, in that first meeting. In that first meeting, or in the couple of meetings, the initial ones, to be talking about those types of potential issues and common issues that are definitely going to keep increasing as our housing costs keep increasing in California, and as health care costs keep increasing, right? These are more and more common scenarios to keep costs down, to keep money within the family, to adequately care for our loved ones. So these are common problems, right? Did this person plan for this scenario? Have they updated their trust? Did they create a trust in 96, start this type of arrangement in 2018, and now we're in 2025? Nothing was changed in the trust to provide for this. There was no meeting with the estate planning attorney to reevaluate the circumstances, right? And I tell everyone with estate plan this: every 3 to 5 years, you should be meeting with your estate planning attorney, or at a minimum, reading your trust. Does this still reflect my current situation? Have there been deaths? Have there been marriages, divorces, births, graduations, and relocations, moving places? Have I inherited assets? Has my significant other inherited assets? Have our own assets grown? Have we started a business? These are things you need to be meeting with the attorney. And by you meeting with the attorney, by you updating your own estate plan, you are helping your named successor trustee. The more current, the more updated, the more thorough that your estate plan is, the easier it is for that successor trustee to follow instructions, right? Now, if there are no instructions, again, we'll walk you through that. And there's always the ability to go to court to get the court's instructions, to get their approval of something. So there's always some safety nets that you can always go to, whether the beneficiaries or family members like that or not. Okay. Lastly, before I kind of switch the slides here, it says notify heirs. This is a really current topic that comes up. People ask constantly, what is the difference between a beneficiary and an heir? And I'll give you a perfect example. Okay. I'll use my parents and my own family. I have one adult brother. Okay. And we are 50-50 beneficiaries, I believe. of, of my parents' trust. They could change that, right? During their lifetimes, they could say, you know, Mark, you've been a terrible child. We've estranged from you. We don't want to give you a dime, right? And they'd have the ability to do that. But let's say for the purposes of this argument, we're 50-50 beneficiaries. And at some point, my parents go do that. They meet with their estate planning attorney and they completely disinherit me, right? I'm completely removed. And my brother is named as the successor trustee, and he's named as 100% beneficiary, right? He meets with an attorney, he deals with it, and the attorney says, "Hey, you have to give notice to heirs." And he goes, "Well, I'm the only beneficiary, you know, under California law. If I'm the only beneficiary and I'm the trustee, I don't have to give notice to myself," which is true. But in that case, what happens if my brother was the one who took my parents to the estate planning attorney? What if it was under my brother's influence, undue influence, inappropriate influence that created the idea in their head that they should remove me, right? If I do not receive notice as an heir, I will have no ability to challenge the trust. Right? I'll have no ability to file a lawsuit in court saying, hey, look, my brother brought them to an estate planning attorney. Both my dad was 98, my mom was 96. They both have had dementia for 20 years. And my dad is blind and my mom is deaf. How in the world could they have had capacity to make these changes? Right. And in that kind of slam dunk case, I would win that lawsuit. But if I don't receive that notice, and that's kind of what California law is doing here, hey, this heir, right, is still getting notice so that they can file the action. One, two, so that there's a clock that starts ticking, right? I want to give notice to that heir because I don't want them to have an indefinite amount of time to file that lawsuit. I want them to have a limited amount of time so that they have to make a choice, right? We put the ball on them. They need to do something or not do something, or they lose out on their right to do so. Okay. And I can, notice to beneficiaries, that could be a series of its own. And maybe we even do that. Notice beneficiaries so people can understand that and what that entails. A lot of times people don't like to hear that. A lot of times people, I can't tell you how many times trustees come in and go, well, my sibling this or this person was disinherited. And I go, well, yes, that may be the case, but based on the planning that was done or not done, we still have to give them notice. And they don't like that. And unfortunately, I have to say, look, it's not whether you like it or not. You're required under California law. And not only that, it protects you and it protects me. So we're going to have to do this. But yeah, again, just something to be aware of. So it's not kind of a surprise. Inventory and valuation. These are all aspects that'll be done kind of more in the middle phase of the administration. I'm not going to focus on it too much because it's not really the first things that need to be done within the 30 to 90 days. This is really more of like okay, we're 3, 4, 5 months into an administration and we're doing this. Okay. So normally the state administration attorney or the attorney's office will prepare a detailed date of death inventory of all assets, whether it's trust or non-trust. Okay. I could have a joint bank account with my parents where it's my mom, my dad, myself, right? That is not a trust asset. That's a joint account. And if they both pass away, that account would just go to me. But it was still an asset, basically as of the date of their death. We're going to want that information. We're going to put it on the inventory, but maybe we put it under the non-trust portion. So this goes hand in hand with asking the trustee to bring all those statements to the first meeting. If you have those or close to date of death statements, you've expedited the process. You've come in with all of the statements, all that information, and we're going, oh wow, all we have to do is just basically drag and drop the values into this inventory and then send it to you for your review and approval. And now we have a date of death inventory that's done, right? So the more information you have, the better, the quicker and easier that is. I will note for personal property, we usually do not itemize each piece of someone's personal property. We're not going to put 10 spoons, 10 forks, fine china, 10 pieces of fine china, antique, like a non-valuable antique rocking chair, right? We're just going to aggregate personal property, estimated resale value currently maybe $10,000. The only time we would say get an appraisal of personal property is if it's a high value. You have a collectible baseball card, mint condition. You know that when you bought it, you talk to collectors that it's worth 100,000. Your loved one knows it was worth 100,000. You're going to want that to get that appraised. You have a collection. You have a Rembrandt art. Let's say a piece of a rare Rembrandt art or Picasso painting or something. It's obviously those are going to be individually appraised. So you may have two things on inventory. You may say tangible personal property, 10,000, and then you may have a couple of items. Hey, this 7 carat ring was worth $100,000. This Rolex watch was worth $35,000. This memorabilia, sports card, mint condition, whatever it is, it's worth on the resale market appraisal $100,000, right? Now it's not what they purchased it for; it's date of death, resale value. And I think that's where a lot of people also get caught up. It's not that they purchased their refrigerator for 5,000, and 20 years later, it's not worth 5,000. It's probably worth 500, right? Or even less. So just be aware of that. We're not listing the personal property. We're doing an aggregate. Something to be aware of. Again, you don't need to come to the first meeting with that information. Arranging for professional appraisals. In almost all instances, we're going to instruct the trustee to get a date of death certified appraisal of real estate. So you're going to want to get a real estate certified appraisal to value the property as of the date of death. Okay. Now, again, a lot of times if you're working with escrow agents or realtors, they're going to say, let me just give you a broker opinion letter, real estate opinion letter. I've been handling probate and trust sales of property for 20 years, and you can just do this. That's absolutely wrong. And I don't know why anyone ever relies on the real estate agent or the teller at the bank or the broker to give legal advice or any tax advice, right? There are numerous other reasons why those valuations are necessary that they are not aware of. Okay, so you're going to need that certified appraisal for the date of death inventory value, for your capital gains and readjusting cost basis, for depreciation reset, for inventory or accounting purposes for the beneficiaries, for determining final distributions. You can see there's a whole host of information. Again, high value personal items, already touched on that, so I'll kind of continue moving forward here. And then securing and protecting all physical and digital property during the process. If you're the trustee, you're going to put your name on title. You're going to open up a new trust account. You're going to take the cash accounts, consolidate, put in your name as trustee. That is securing cash assets. Securing digital property is very difficult. Very difficult. It's getting better as we move forward in society and as time goes on, but very difficult. A lot of digital property you can't access. A lot of it you can't even name or put in the trust currently. That's changing and getting better. Cryptocurrency is a much more prevalent area of digital assets now. Try putting that in the trust and try dealing with issues in that regard. So that's getting much better. Talk to the attorneys, talk to the companies, and they'll kind of work you through that process. But being aware of that is very useful. Okay. Record keeping and compliance, extremely important. The second that you take over as trustee, whether it's during your loved one's lifetime, right? Because sometimes the loved one will step down or they become incapacitated and you are the trustee during their lifetime. You need to maintain clear, detailed records. Okay. And that means if you're making, I would advise, let's say your loved one becomes incapacitated and you're the named successor trustee and you take over that role. And the date that you take over, right? Maybe you open up a new account in your name as trustee and you transfer all the funds into that new account. And you go, Mark, why would you do that? It just makes me, it's an annoying step. And I go, yes, it's annoying, but now you have a very start from the very beginning of this account. This is only an account that's going to receive income for this person, and it's only going to have credits and expenditures going out on behalf of this person. So you have a detailed ledger already built in of expenses for this individual in the trust and receipts coming in for the individual in the trust. And it'll, and again, you can even keep a separate Excel sheets for expenses saying, the stuff that's coming into this bank account isn't very detailed. It just has the amount and the date, sometimes the payee or payor, but a lot of times it doesn't have the payee or payor or the purpose. So you're keeping a nice spreadsheet that's saying, okay, I paid this on this date and this is what it was for. I paid the property taxes for this property on this date. I paid the property taxes for this other property on this date. I paid for maintenance and upkeep for this property. I paid lawn mowing services. I paid for healthcare. I paid for this dental visit out of the district. You're keeping detailed ledgers of everything. And then you have a separate spreadsheet that says, here, I came out of pocket. I was out with this person and I didn't have the trust checkbook with me. So I made a payment on their behalf out of my own personal pocket. Keep a ledger of that and you reimburse yourself, right? You're maintaining clear and detailed records. Also, you're keeping track of your time as trustee. Keep track of the time you spend on behalf of the trust. Most trusts and California law provide for trustee compensation. Being a trustee is a job, right? But to get paid just like you do for most of your jobs and most of our jobs, right? You have to keep track of your time. And there are formulas and calculations from how to calculate that, but it's going to be very hard if you're not tracking that time. Okay. Notifying required agencies and creditors within legal timeframes. The attorney will walk you through that process. Normally that's notifying any lenders, notifying property management, notifying. I would say other than those two, really speak with the attorney first before you notify creditors. We will provide you with the timeframes and those legal requirements. Depending on what your particular circumstances are, we may not want to notify or may not be required to notify. So I want to be very, very particular about that. Discuss that with your estate administration attorney, okay, before you do anything. Prepare for periodic updates to beneficiaries and your first full legal meeting. This is more of an, kind of touches on some other things I've talked about. You're going to want to provide periodic updates to the beneficiaries. This is a communication. Okay. It can be very vague and very limited, but it needs to be reasonable to allow them to know, okay, trustee didn't really give me too much information, but I do know that they've just hired a real estate attorney, a real estate agent, and they're about to list the property, and they expect to list within the next few weeks. They expect to list for this amount. And then, the trustee said that they'll update them as that sale process moves forward and as they're ready to accept an offer and as blah, 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 yada, yada, yada. Okay. You don't have to notify a beneficiary every day. It doesn't have to be every week. It doesn't have to be every action, but it has to be of the material major updates. And you're going to want to do that because there may be some times where you need beneficiary input. Hey, there's three of us. There are plenty of assets to give to these two individuals. I know that this individual has indicated a desire to keep this house. If it's $1 million house, $3 million estate, well, okay, we can give $1 million cash to this person, $1 million investment account to this person, and $1 million home to this person. And in that case, you're going to have to be talking to the beneficiaries to be gauging their interests and their wants and desires. And you as trustee, it's your role to try to accomplish those wishes and desires to the extent reasonable. And that's when you're talking to the attorney. Is this feasible? Is it reasonable? Is it lawful? Is it what the trust says? Right? And we're walking you through those aspects to make sure that you're doing what's appropriate. Okay. Common mistakes, what to avoid, acting before understanding duties. We have trustees who start doing a bunch of things and then come to us midway through the administration and go, oh, I've run into this issue. And we kind of go, well, we need to also see what else you've done. And, we look at it and we go, oh, wow, there's a lot of mistakes here. This was done incorrectly. This was done wrong. It's missing this, right? So I would highly advise that before you start making any decisions or any transactions or signing anything, that you understand your duties. Meet with an administration attorney, go over what those duties are, what an administration is, what the trust says, and become informed. Like any other, decision you make, become informed before you make those decisions and actions, because there could be ramifications. There could be big ones because beneficiaries could end up suing you for actions that were unlawful or incorrect or directly in violation of the terms of the trust or California law. Missing deadlines for notices, filings. This is very important. The attorney will really walk you through this aspect. So I won't get too detailed into that. If you have any questions on any deadlines on your particular matter that you're currently handling, please reach out to us and we'll take care of that. Or if you're represented by another firm, make sure you reach out to them, to whoever the estate administration attorney is, and make sure to discuss that. Distributing assets too soon. A lot of times this is a very contentious aspect because we're going to tell the trustee, well, don't distribute the assets until XYZ has occurred. Make sure that you've accounted for taxes. What about capital gains? What about these issues? What about a contesting beneficiary? If they sue you, do you have funds to be able to defend the trust? If you distribute the assets, once you've done that, it's very hard to collect those assets back from beneficiaries, right? If you give a beneficiary $100,000 and ask for it back a year later, they most likely spent it on expenses, debt, their own creditors, vacations, their family, their needs, their house, you name it, and the cash is gone, right? So it's very, very difficult to recollect those assets once you've done it. That's a common theme I've seen from trustees who meet with us much later in the administration process. Now, that doesn't mean they can't make preliminary distributions in certain instances. Again, you'll want to talk with the administration attorney about if that's feasible or viable and what your particular circumstances are. Poor record keeping, that I think is self-explanatory. If you have poor record keeping, it's easier for beneficiaries to articulate or make an accusation that you are mismanaging the funds or that you are not doing things appropriately. And I think that holds true for anything in our lives. Foregoing updates to the beneficiaries, it's kind of redundant. I think we've kind of touched on that. You're going to want to be communicating with the beneficiaries timely. Again, doesn't have to be every day or every week necessarily, but you're going to want to do it timely and for major decisions. Please discuss that with the attorney as you kind of move forward to administration and even talking in the first meeting how to approach that, some strategy, and how to like I said, approach that and move forward in an effective and appropriate manner. Protecting yourself as trustee. Again, these are just some key aspects for the first 30 to 90 days prior to becoming a trustee and even all the way through a trust administration. I really think all 4 of these will hold true no matter what the scenario is. Keep thorough records, communicate clearly and consistently, seek professional help, follow the trust terms in California law, know and again, I'll kind of reiterate, and when you communicate clearly and consistently, seek professional help, as a part of that, you'll have the discussion of, oh, am I the right person to be doing this? Or is someone better suited? Or should someone take over for an interim or for a certain period? Or do I have the power or the authority to delegate tasks to other individuals? That's all going to be a very healthy and prudent discussion to have with the attorney in that first meeting. And you're kind of gathering your thoughts on that and getting ready. And that can be done in the first 30 to 90 days, right? Where am I at? What do I need to be done? Do I need help? Do I need to step down? Or am I going to move forward with this? And then what does that look like? Okay. Key takeaways, really being proactive is almost always best, right? Being reactive, you know, although not always avoidable, we want to avoid it if possible. But again, like I said earlier in the webinar, there just are certain circumstances where it's unavoidable. Some things you can't forecast, some things you can't plan for. Life will always be life. I think we all know that there's going to be variables and things thrown at us that none of us can anticipate, even reasonably anticipate, right? It may be completely unforeseeable, completely unimaginable that we are dealing with. And the idea is try to be proactive, try to be planned to the extent that you can, but give yourself grace, right? If you've done what you need to do, if you're prepared, give yourself that grace, be proud of yourself. There are things that are going to come up that you can't deal with. We will walk you through that. The idea is to try to reduce the stress to the extent possible. But I want to reduce my own stress. We want to reduce your stress, but all of it will not be avoidable, especially at a time when you've lost a loved one. It's a very difficult time in life. So there's just some things that are going to come up that, being proactive is very helpful, but, just again, give yourself grace, give yourself some leeway. Don't be too hard on yourself. You're going to do your best. You're going to honor this person's wishes to the best of your ability. And that's all you're expected to do from our end, from the legal end, from the law's end, from the state's end, and from a religious or a spiritual end. Okay, so this is again just kind of a wrap up here. Understanding your legal responsibilities from the start will help completely, right? This is being proactive, knowing what documents, knowing what to do if documents are missing or incomplete, right? Knowing that you don't have access to this or don't have access, you can tell that to the attorney and they will walk you through that. Learning who handles burial decisions and how final expenses are paid. Very good information to know, especially in the 30, 60 day, 30, 90, 30, 60, 90 day period, because of that's usually when the funeral and the ceremony and what disposition of remains is occurring and who's getting the death certificates. How is that being paid for? Have others paid for it? Do reimbursements need to occur? How does that look like? How is that process accomplished? Okay, gathering the right documents, kind of, again, this is real key takeaways here. Try to give as much information as you can. If you don't have it, not the end of the world. We will walk you through that. And that is, that is common, right? It's not everyone who comes in with all of this information. It's very common for people to come in and say, I don't have this information, but I do have this person who I can contact and reach out and get the process started. Okay. Know which beneficiaries and agencies to notify and when. Really, that part, I will say not really too important for you to know. That's more important to have that discussion during your first meeting with the attorney. excuse me, and then practical steps to manage and protect trust assets effectively. Again, that's knowing what assets there are, what the family dynamics are, what creditors there are, what tenants, what issues, and that's all things you can discuss. Knowing that information, bringing it to the meeting will definitely increase the likelihood of your ability to protect those assets timely, effectively, and cost efficiently. Okay. And if you've ever met with me on a trust administration, I will tell you, trust administrations are expensive, they're timely, they're stressful, they're confusing, they're complex, regardless. Sometimes they're that way, and somebody only has a house and a bank account. But that doesn't mean that because their asset makeup is clear and concise, that doesn't mean the administration will be. So trying to do all of this in advance, or doing your best to compile this prior to the meeting, or prior to administering the trust, will only help you as the trustee in the long run. Okay, so that's the conclusion here. Kind of some wrapping up things, some next steps, help you to meet, basically, kind of how can we help you to meet deadlines, protect assets, reduce liability, provide the tools and guidance to handle trustee duties, help protect you from disputes, and ensure compliance. Again, we do all of these things, you do all of these things, some things are out of our control. We could be the most proactive, most prepared attorney, and you could be the most proactive, most prepared trustee. That doesn't mean that someone's not going to sue you, right? That doesn't mean you can control what happened during your loved one's lifetime. It doesn't mean that it could be a business partner that's suing the business, but who owns the business? The trust, and now you're intricately involved and have to take action, right? We're doing the best that we can. We'll help guide you. That will try to help prepare you for those unknowns and those variables. Okay. My Copenbarger, this is just some information about our firm when we opened, the attorneys, our experience, our advanced degrees, we have numerous individuals with advanced tax degrees, numerous certified specialists, and kind of our locations again. And this is our contact page. Please check the message in the chat. We're having a little bit of an issue with our webinar evaluation. Check the message in the chat and you'll be able to give feedback via that method. Please contact our office if you want to need a scheduled appointment. I always like to hear back from everyone from my webinars. I want to hear back constructive criticism. Hey, Mark, we love that you did this. We love that you covered this, but we wish you went into this more. And at that point, it allows me to say, hey, okay, I didn't go into that point more because you need to make a personal individualized meeting with me. Or it's like, hey, marketing team, I had 30 people message me about this. Let's get a webinar going specifically on that topic. Okay. Or if you have something disparaging to say about my communication style, please, no harm taken, no insults. If there's anything I can do to improve my communication, how to effectively get the information to you, that's the whole purpose of this. So if there's something that I am deficient in that will help anyone, whether it's a client, a family member, or the general public, understand these topics better and be more prepared, I am all ears. We are all ears. So I'll go ahead and leave this up for a few moments. But once again, thank you for joining me today. Really appreciate it. Like I said in the beginning, we're going to try to come up with a series of trustee based webinars. They may not be as long as this because they may be more focused, that we really think will help you in the future and really understand the role of the trustee. So we'll try to come up with that in the future. We look forward to hearing from you. Thanks again. It was lovely kind of speaking with you today. I kind of went over the time frame, so I probably won't have time to answer any of the questions. Feel free to email those. A lot of times the marketing will shoot me those in an email or message, and some of them I actually am able to answer without an actual meeting. So again, thanks again for joining us. Take care. God bless, and hope to be seeing and talking with you soon. Okay.